Yesterday, a federal district court judge in D.C., John D. Bates, overturned President Trump's decision to end the DACA program. The judge was appointed by George W. Bush, ruled that Trump's action was arbitrary and capricious because the Department of Homeland Security failed adequately to explain its conclusion that the program was unlawful. Well, this judge ordered the administration to continue to accept new DACA applicants, but he's delaying the implementation for 90 days so that the Trump folks can rewrite their basis for ending DACA. Now, if this ruling stands, it could actually mean the tripling of the number of illegals ultimately protected by this Obama-era program. DACA would then be open to an additional 1.2 million more people, according to an analysis by the Migration Policy Institute. And that's on top of the nearly 700,000 already protected by the program. The very idea that one unelected district court judge could have this type of power should outrage every American. I don't think any serious legal scholar really thinks that President Obama had the constitutional authority to wave his noble hand and grant 700,000 young people de facto citizenship. I mean, remember, he gave them the right to work here without fear of any deportation, all by this executive action. And remember, when the Democrats had the majority in Congress, they failed to pass broad-based amnesty. So Obama, through his Homeland Security Secretary Janet Napolitano, decided he was going to do it on his own. And this was done despite the misgivings of his own Justice Department. But nevertheless, Obama pushed it as far as he could.
The bill hasn't really changed. The need hasn't changed. It's still the right thing to do. The only thing that has changed, apparently, was the politics. It makes no sense to expel talented young people who, for all intents and purposes, are Americans.
Yeah, that whole citizenship thing, all those millions of people who came here legally to get citizenship, that's all a formality, Mr. President. What President Trump and his administration did by rescinding DACA was to actually restore the rule of law and return immigration decisions and the fate of those DACA kids to the constitutionally appropriate branch of government, Congress. Yet district court judges from San Francisco to Brooklyn and now here in Washington, D.C., have stymied this president at every turn. This is totally absurd and an abuse of power. Now, you might be asking yourself how we got here. And how did we get to a point where people from foreign countries believe that they can crash our borders, game our immigration system, and then ultimately just wander freely in our country? Well, the answer? One out-of-control judge in California had a lot to do with it. Her name is Judge Dolly Gee. And in 2014, we saw, remember, a mass influx of illegals crossing our southwest border. And remember, the Obama Department of Homeland Security placed a lot of those illegal immigrant family units in detention facilities. Well, in 2015, Judge Gee ruled that the government could not detain the children in centers set up, all those centers set up in Texas, because the judge ruled they were not safe and sanitary enough. And she based that decision on this 1997 settlement agreement, it was called the Flores case, that required that unaccompanied alien minors be released into the country without delay. And this Judge Gee went even further, ruling that not only should the minors be released into the United States once apprehended, but their parents should be allowed to go free as well. So again, that one district judge in California is responsible for the release of an estimated 107,000 unaccompanied minors into the interior of this country since the year 2016. And then also most of the 167,000 apprehended family units released as well. Again, think this through. One district court judge has forever changed our cultural, demographic, and economic, perhaps national security landscape. One judge. That is not what our founders intended. Now, let's face it. The runaway judiciary has become, in effect, a new flank of the resistance. They're taking away your power. And it's time for Congress to circumscribe the authority and the reach of these district court judges. Think about national health care policy, immigration policy, national security. These matters are all beyond the scope and understanding, frankly, of a district court judge. It's like giving a local mayor control over U.S. foreign policy. It's ridiculous. Remember, the Constitution, Article 3, Section 1, states the following. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may, from time to time, ordain and establish. And it continued. Now, what does that mean? That means the Congress can regulate the lower court's jurisdiction. And it's time they do. In fact, they've done so in the past. Congress should immediately pass legislation establishing that any cases touching on important national security or national economic concerns should be referred to the appeals courts or the Supreme Court directly without delay. Or at the very least, constitutional determinations of the type we're seeing in this DACA case, they should be referred to the appellate judges, three-judge panel, or maybe even the en banc panel of the whole court. They're far more knowledgeable in constitutional matters and far more knowledgeable on all these matters, God bless them, than the district court judges. The tyranny, especially of the district court bench, has to end. And the people's will should no longer be held hostage to the capricious whims of one ill-equipped, disgruntled, life-tenured jurist. And that's the angle.